May I please, your lordships?
Yes.
Lordship, I beg to mention item number 7 on behalf of Mr. N.K. Borua, the engaged legal aid counsel. He is out of station. Yes. We have informed the other side also.
NK,
Borua, item number 7.
I can't see his name here.
7.
Item number 7.
Oh, 7. That is 6 and 7.
6 and 7 are.
But you have not given your mention slip.
Lordship, yesterday night I informed her over.
They told me last night that Mr. Borua is in Aizawl. He called me up from there.
On request made on behalf of NK Bora, Learned Amicus Curie. For the appellant in criminal April GL 101 of 2019. List these matters again after.
On 11th May, it may be listed.
You want a date fixed?
Date fixed. Or if after 2 weeks, that's
After 2 weeks.
deeply obliged.
May I please, your lordship? Let's say I beg to mention item number 9 of today's list listed.
Yes,
So with the consent of the other side, lordship, matter may be adjourned, lordship.
you are appearing on behalf of
On behalf of SG Borua, lordship, B Borua.
B. Borgoin. On request made by Mr. B. Borgoin, Learned Counsel for the appellant. List the matter after.
Lordship, on 25th May. Thursday.
On 25th.
Much obliged, lordship.
May I please, your lordship. Lordship, regarding item number 2, my lord, is that we have taken consent and adjournment from was deposited, my lord.
Hmm.
Yes, there is some personal problem of my senior, my lord, jet cover, my lord. My lord, pass over the matter for the day, my lord.
On request made on behalf of the Kamal, Learned Counsel for the appellant. List the matter after 2 weeks.
Oh, my lord, 9/5, my lord, maybe.
I'm saying after 2 weeks.
Lord, it date will be fixed, my lord, kindly, my lord. If the
Yes.
date is not fixed, my lord, it is very difficult to listing, my lord.
You make a mention later on.
My lord,
Lord.
bless you.
Item 1 of daily list hearing.
May I please, your lordship, I beg to mention item 4.
Yes.
Lordship, my senior could not appear today due to some medical emergencies. May
No
kindly be-
mention slip. Have you informed the other side also?
Just now I've come to know.
Then I have no instruction, lordship.
Who's your senior?
Mr. F. Khan, lordship.
Yes, Jahan.
Lordship, I have no objection. Some medical emergency, she said.
On request made on behalf of Mr. F. Khan, Learned Counsel.
Madam, may kindly be listed after 2 weeks, lordship.
List the matter after 2 weeks.
Obliged, lordship.
Item 1.
Is that matter?
Next, your lordship. On the other day, already I had submitted on the merit and other parts, lordship. Just today, I am pointing out one aspect, lordship, regarding that evidence of PW 16, that he was not declared hostile. So prosecution is bound by his evidence, lordship, that I have given 2 citations, lordship. One of Supreme Court and one of our division, our High Court division bench, where that judgment is relied on, lordship. That Supreme Court judgment is Rajaram versus State of Rajasthan, lordship.
Para?
Para 20, para 9, lordship.
Yes.
But the testimony of PW8, Dr. Sukhdev Singh, who is among neighbor, cannot easily be surmounted by the prosecution. He has testified in very clear terms that he saw PW5 making the deceased believe that unless she puts the blame on the appellant and his parent, she would have to face the consequences like prosecution proceeding. It did not occur to the public prosecutor in the trial court to seek permission of the court to hear PW8 as a hostile witness for reasons only known to him. Now, as it is, the evidence of PW8 is binding on the prosecution. Absolutely no reason, much less any good reason, has been stated by the division bench of the High Court as to how PW8's testimony can be sidelined. So here also he was not declared hostile, PW16, who stated that Moinul took the deceased with him, Lordship. And this judgment is also relied on by division bench of our High Court, Lordship, in Sharifa Khatun's case, paragraph 20, Lordship will find.
Yes.
In the case of Rajaram versus State of Rajasthan reported in so the Supreme Court has observed that prosecution witness who did not support the prosecution case and not declared hostile with the permission of the court, his evidence would be binding on the prosecution. Therefore, the evidence of PW 5, 6, and 7 who did not support the prosecution case would be binding on the prosecution. So this is what I wanted to place before your Lordship. And other things already I have submitted before you. I will reply to her if anything requires, Lordship.
Lordship, I beg to, as an amicus to your Lordship, I just want to point out what my learned friend has mentioned. Only wanted two parts. One part, I want to argue the matter on the part of approver. And one part of this medical of the doctor. The other rest of the parts have already been argued by my learned friend. Here in this case, your Lordship, if your Lordship peruse the page 34 on the part of the investigating officer.
Yes.
If you Lord, in the page 34, your Lordship, in examination shift, there is a mention 1, 2, 3, 4, 5, 6, 7, 8 line. In the back, we found one photocopy of divers of the deceased lady along with some dresses. One photocopy of divers, sir. Lordship. Then, how it came, I will place before your Honorable Court. Page 35, your Lordship. Again, in the midst of the part, it has been mentioned in examination shift, the whole scene was video recorded with the help of UBC 130.
Which line?
Your Lordship, around 10 lines. In the midst of the line, your Lordship. I said 1, 2, 3, 4, 5, 6, 7. 21 line. There is a part, the whole scene was video recorded, your Lordship. Bottom from the 6 or 7 lines above. There is a mention, your Lordship, the whole scene was video recorded with the help of UBC 130Ts, Chandra Kumar Singh of Saptagram PS, and he video recorded with mobile handset. Thereafter, the Azhar named Moinul, son of Toyeb, was produced before the court with a pair to treat him as a state witness, and statement was recorded under 164 CRPC. I recorded the statement and draw a sketch map of the occurrence. So on the basis of 164 statement, your Lordship, he was treated as a state witness or approver in this case. What my learned friend had already been mentioned, your Lordship, to be 304, 306 IPC, CRPC, your Lordship, tender of pardons, your Lordship. In paragraph 3063, your Lordship, what the section says, your Lordship, every magistrate who tenders a pardon under subsection 1 shall record his reason for doing, whether the tenderer was not accepted by the person to whom it was made, and shall on application made by the accused furnish him with a copy of such record of free of cost. Then, your Lordship, paragraph 3064, your Lordship, what the act says, your Lordship, every person accepting a tender of pardon made under subsection 1 shall be examined as a witness of the court of magistrates, taking cognizance of the offense and a subsequent trial, if any, shall, unless is ready on bail, he detained in custody until the termination of the trial. So these are the preliminary conditions to be as a state witness. Now, assuming your lordship, if a person treated as an approver and thereafter he tell the false statement before this honorable court, then what is the consequences for that? That says in the section, your lordship, 308. Trial of person and not complying with the conditions of pardon, your lordship.
1 minute.
আপুনিতো কথা কৈছিল কোৱাচোন তাত কথা তাত এই মানুহকেইটা এই জাজ কৰি আছিলে
Yes.
3081, wherein regard to a person who was accepted a tender of pardon made under section 306 or 307, the public prosecutor certifies that in his opinion such has either by willfully concealing anything essential or giving false evidence, not complying with the condition or which the tender was made, such person may be tried for the offense in respect of which the pardon was so tendered, for any other offense of which he appears to be guilty in a connection with the same matter, and also for the offense of giving false evidence. Now, your lordship, we have to justify the substantial question of law that whether that person who are competent as a witness under section 315 of CRPC, where we treated as a competent witness, he must be scrutinized. And that should be certified by the public prosecutor that until and unless a person who is treated to be an approver, your lordship, he must have some directly, indirectly involvement of this case, your lordship. Now, here in this case, if lordship permit me, his statement, your lordship, his statement on page 39. PW 21.
Yeah.
Lordship. In examinations, if your lordship, what he said, I know the informant Laskar Ali and his deceased daughter, Hasina Begum. I know the accused person, Moinul Haq and Monimul Haq and accused Bachu. Now we start, sir, your lordship. I met Hasina in a marriage party prior to the incident, your lordship, and became a friend. At that time, my first wife left me, went to the parent house, and she wanted divorce from me if I pay money to her. As I don't have money, I told this fact to the Hasina and told her and would marry her at that time of marry her. And at that time, Hasina and me are in love. So in his love, your love angle, there is a condition. If you paid me 30 to 35,000, I will pay it to my first wife and you will be seeking the divorce. That is the condition. Prior one they have met before the accident in one marriage party, your lordship. In that marriage party, he given condition that I am going to marry you, and if you give me a satisfied amount, which I will pay to my first wife. Now, your lordship, then what he said, your lordship, the parents of the Hasina also gave consent my marriage with Hasina. Accused Batsu is mason my profession, and I was working under him during that time. I told it a opposite fact, if he could afford me rupees 30 to 35,000, then I may get divorced from my first wife and would marry her over phone. At the time of talking with her phone, accused Batsu was present, and Hasina replied that she would give it 30,000. And I told her to come with her guardian, and I will meet her with my guardian. Thereafter, leaving my phone, I went to the answer Nasail call. At that time, Batsu took Hasina mobile number from my mobile handset and called Hasina, asked to bring the money. Now, your lordship, again start, your lordship. After one day, brother-in-law called me over phone and told me that Hasina is missing, and he is also remind me that myself in love with Hasina at about 1 p.m. On the next day at about 4 p.m., I got information that the dead body of one lady is recovered at a jute field at Kadomtola. Now, my humble submission before this honorable court, the exchange of love between take place up to 1 p.m. on the prior to the accident on that day. The accident was occurred, the incident, the murder was occurred on 3 p.m. on the next day, and he got an information at 4 p.m. Now, this have been allegedly was charged by his brother-in-law of Hasina that you have been in contact with him for last 1 p.m. Now, my humble submission before this honorable court, that is the only reason That is the only reason the investigation officer failed to take the details of the telephonic calls, mobile calls. If it has been traced out, if lordship connected with this case, your lordship, if it has been traced out, that that one person has charged against me, that you have been contacted on the last night with Hasina at 1 p.m. your lordship. And if you go to the your statement of the police, your lordship, he also said, the police also said that I did not take any LCR. I did not take any telephonic calls on details. Why, your lordship? If you put on video report, to test out the things, your lordship. If you put in one PW3 Brian person is the shopkeeper where the persons have taken the 2,000 rupees, it has been presumed. Then why he has not adduced any evidence on the details of calls and which have been charged by the brother-in-law? The allegation against the Moinul Haq, who is the approver of this case, your lordship, he has charged that at night 1 p.m. you have been talk with my elder sister.
At night, afternoon.
Yes, at night, in late night, your lordship.
No, 1 p.m. is afternoon. Isn't it? You are not wrong.
1 p.m.
At about 1 p.m. your lordship.
That is afternoon.
That 1 p.m. also, your lordship. The correspondence between her will be described if you find the details of the mobile calls, your lordship. Second point, your lordship, my humble submission before this honorable court. One divorce paper was recovered at a dead body by the investigating officer. One divorce paper was recovered. And if you go to the seizure list of the divorce paper, you will find that prior to the accident, Hasina came to that Moinul along with the ornaments and money. There is nothing mentioned about the divorce paper or any wearing of the garments. Now, how she has got the garments? Now, my humble submission before this honorable court, if she has gotten divorce paper of whom? She ought to have got the marriage agreement paper or marriage certificate.
No, that is reflected in the Caesar list.
Yes, your lordship, it is.
Divorce of her with her previous husband, not Moinul's. It was her divorce with her previous husband.
Lordship, if you go to the page 107, that is a Caesar list, it has been mentioned, one photo state divorce affidavit of Hasina Begum. My learned friend will tell, page 6, one photo state divorce affidavit of Hasina Begum,
With Gulzar
daughter of
Fakir.
Loskar Ali Yel Kusarkutti, PS Saptagam Gologas.
With Gulzar Fakir.
No, in this paragraph, the Caesar list of the 107 is 6.
With Gulzar Fakir.
Let me,
yes.
you have a time here, madam. My submission is that you're 107, page 6, point 6.
Yes.
One affidavit, divorce affidavit, one photo state divorce affidavit of Hasina Begum. Who is Hasina Begum? Me, the deceased person who has been died. Now, divorce paper relates to whose case, your lordship? That means the deceased person ought to have made with earlier person in that condition, that I have also divorced, you also been divorced, then we meet each other and we're going to marry. Prior to the subject to the condition that I will pay you 30,000 rupees and ornaments, and thereafter this divorce, the paper which will be signed, that will be settled and we will going to marry. But in this case, your lordship, she has been, the investigating officer has received one divorce paper of Hasina Begum. How it comes, sir? This is the game plan of the Zoinul Ali, your lordship. Because I am not going to all the friends have mentioned. I just going to Position story. She came to meet Zoinul, or Moinul. That Moinul has his own native village. Thereafter, she went to some other place. The mother of the deceased person also mentioned that my daughter has went to Moinul. Sister of the deceased person also said that this is the Moinul. The photocopy of the divorce copy, which have been received from the custody of the deceased person, how she has got. This is the Hasina Begum where this Zoinul has mentioned with his first wife. So entire case, if you lordship find your lordship, and he said in the exemption period about On the next day, about 4 p.m., I got an information that a dead body, one lady is recovered at Jute Field at Karangal. He pretending himself that he is no way connected with this case. And the state approval has been mentioned where there's a leading case of factory, leading factory, your lordship, discovered some unmaterial substances. Here, if you lordship, if you go to the evaluation of this PW21, you will not find any case where the accused person are directly or indirectly involved in this case. There's nothing a single word say mentioned about. Now we presume I presume as a state witnesses when we under section 316 they're competent as a witness when we did it, where there's some prosecution have been disturbed and this is the person where we can go to the next course of action. Is there any mention in this evidence? And how in the sections clearly mention, your lordship, when you are not in bail, when you are scrutiny, when the public prosecutor certified that, then and there it will come, your lordship. Now this entire proceeding, he came or we gave the petition under 164 CRPC before the court and court submitted that. Court accepted that. There is no any whisper of a single mention about what is the reason for we can accept that as a state witnesses, since he himself as a main accused. The other co-accused come in in a letter on, your lordship. Who is the mastermind of this case, your lordship? Who has mentioned to give the 30,000 or 35,000 to pay me? She is a daily wage labor, your lordship. Assuming, your lordship, she paid it, then also she ought to have got the marriage certificate, not divorce certificate.
This divorce certificate is of some other, her earlier marriage.
Earlier marriage of not Hasina Begum, your lordship. It's the earlier marriage of the first wife, husband of the Moinul, your lordship.
How?
He mentioned, I met Hasina in a marriage party prior to then we became friends. At that time, first my wife left me and went to the parents' house and she wanted divorce from me if I pay money to her. That is a statement. All things have been written in a draft, or maybe all things may be written in some paper where investigating officer found from her custody. Now that is the reason I want to know from the prosecution side how it links with the divorce paper when she come only along with only gold ornaments and money. There is a judgment, your lordship. It is a Madras Bombay High Court. This Bombay High Court, your lordship, as per the guidelines of the Supreme Court judgment, relied on 2001 8 SSC 289, Jasbir Singh versus Bipin Kumar Jaggi and others, your lordship. Just before going to the details, I just only pinpoint only one point, the head note. We are of the view that a grant of pardon by the court under section 306 CRPC on being asked by the accused and duly supported by the state in a judicial act while performing the said act, the magistrate is bound to consider the conjugation of grant of pardon taking into consideration the policy of the state and to extent compare the culpability of the person seeking pardon to the other accused persons. So there is a frameland, there is a guideline, how the magistrate can accept to be treated as an approver. Then, your lordship, paragraph 4 or paragraph 7, there is a judgment, your lordship. That judgment, famous judgment in the Lieutenant Commander Pascal Fernandez Supra, that is paragraph 7. The judgment quoted, it has been mentioned, your lordship, ordinarily it is for the prosecution to ask that a particular accused out of several may be tendered pardon. But when where the accused directly applies to the special judge, he must refer the request to the prosecution agency. It is not for the special judge to enter a ring as a veritable director of prosecution. The power which the special judge exercises is not on his behalf, but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecution joins in the request. The state may also not like to tender pardon of the particular accused because he may be the brain behind the prosecution on the request of the prisoner. If the prosecution thinks that the tender of pardon will be the interest of a successful prosecution of the other offenders whose conviction is not easy without approver's testimony, it will be undubitably agreed to the tendering of pardon. The special magistrate or magistrate must not take on himself task of determining the propriety of tendering pardon in the circumstance of the case. And that have been repeated in the Jasbir Singh versus Bipin Kumar Jogi in 2001, 8 SSC and 289. So my prosecution stops, assuming your lordship. The next course of action, I need one higher person to be a witness, is competent witness under 315 CRPC, and thereafter we will go to the next course of action. But if you find the evaluation of this paragraph PW21, your lordship, we will not find any case directly, indirectly involved with my appellant, your lordship. This is one of my hold of my argument on the part of the approver, because my learned friend has already been mentioned. I don't want to go the another person. Second part, your lordship, I want to argue in the medical part. That is Mukul Chandra Burman, page 27, your lordship. He is the doctor, your lordship. He Dhubri Civil Hospital. The girl is about 24 years old, your lordship. Lordship, girl is about 24 years old, and if you go to the details of the injuries, your lordship, more detailed description of injury or disease. Ligation mark in the neck is antemortem in nature. Sign of aphasia are evident. And what he said in the open cross defense, your lordship, what he mentioned in the cross. In my post-mortem report, I have not specially mentioned whether ligation was caused by hard material substance or soft material substance. That is a big blunder of the opinion passed by the medical officer. Can a person be given report without in a presumption manner, your lordship? You being an expertise in a medical field, you have to be specified that he should be material substance or soft material substance are used. Assuming, your lordship, if with the 3 persons are in the there, that's also been mentioned. That mention will be in the, if I strangling a neck in a part, your lordship, that gravity of the force which I implied on that neck portion will be found in the ligation examination part. I have found strangulation mark below the neck of the deceased, but I do not mention whether strangulation mark was tough or rough or soft. Constriction causes congestion of blood circulation as well as obstruction to the respiration, as strangulation may found on the neck. Whether congestion is venous or cerebral anesthesia is not present in my report, your lordship. If you highlight, your lordship, the report, the medical report which have been mentioned, there is no clear vicinity to state that whether it is a cause of murder by the strangulation or by some other ways. That have not been mentioned categorically, your lordship. And if we go to the medical jurisprudence of Moody's jurisprudence, your lordship, the strangulation part, your lordship, I just go to the ligation mark, Moody's jurisprudence, your lordship. What the Moody's jurisprudence on the ligation mark, your lordship? What mentioned here? Ligation mark is well defined and slightly depressed, make corresponding roughly to the breadth of the ligation, usually situated laid down in the neck below the thyroid cartilage, encircling the neck horizontally and completely. The marks are multiple if the ligation is twisted several times around the neck. Please note, your lordship. The marks are multiple if the ligation is twisted several times around the neck. How much time I press in the neck to kill the death of a person will be reflected in the ligation mark in the as per the Moody's jurisprudence. Are also the marks are multiple if the ligation is twisted several times in the neck, also more than one firm knot of the ligation. In a certain homicide, the mark may be oblique, as in hanging, if victim has been dragged by a cord after he has been strangled in a recumbent position if the victim was sitting and the assassin applied a ligation on the neck while standing behind him, thus using before the force were upward. No, in the ligation mark, what the medical opinion said, there is no distinction to say at the time of the deceased body whether he was standing, she was standing, sitting, or hanging. There is no mention. If medical report does not confirm the present status of the how the medicals have been, how she was been dead, it cannot be treated as a whole worthy of as a witness of this case, Your Lordship. And second part, in last part, it has been mentioned whether conjunction with venous or cerebral anesthesia is not present in my body. Venous means the nerve, Your Lordship. The moment I stop the blood, the whole body will be circulated, and that 11 point of time, what will be the outcome if I just stop the blood every person and any organ of the body? Second is that cerebral anesthesia means a brain, Your Lordship. While I stop any part of the body, it will be detect in my brain. And how it been brain hemorrhage or how it been stroke. It will be mentioned in the post-mortem report. And that leading is missing in this case, Your Lord. Leading fact is missing in this case, Your Lordship. Now, my involvement in this case is nowhere mentioned, is nowhere can be categorized that I have put my death by strangulation. So, I do not want to take time because my learned friend has already mentioned. Only two parts, Your Lordship. Entire proceeding, if you Lordship go through it, it has always been mentioned, Your Lordship. And I start at page 62, the judgment passed by this trial court, Your Lordship. I beg to mention 60 page. Paragraph 8. I read only this part, Your Lordship. Paragraph 8. The learned defense counsel made submission that except PW1, PW4, and PW1, other witness was not stated the accused person had made confession before the extrajudicial confession of the accused person, being not corroborated by other witness of this case is not acceptable piece of evidence. Next point, sir. He submitted there is no unbreakable chain of circumstances evident to hold the accused person guilty, and the statement of PW1 and PW11 is not corroborated and confirmed by the PW3 and PW12, respectively. The others, PW14, PW16, the mother and the sister of the deceased stated that it was Moyul with whom the deceased having love affair in the Azahar. PW1 alleged that if it was Moyul who has called deceased and she left her house to meet Moyul, and thereafter did not return back to her home, and a dead body was found in between. There is no evidence that deceased was seen with the company of the accused person, and the accused persons were involved in the murder of the deceased. That is the gist point. Then he submitted that the PW1, the father of the deceased, lodged Azahar against one Moyul, son of so-and-so, and that accused person called deceased prior to her death is also not proved, and therefore there is no complete chain of circumstances. The golden principles of the Sarada Vidhi, that judgment, that what my learned friend has mentioned, that Sarad Vidhi, son Sarda, that golden principle, but the first 5 golden points of circumstantial evidence, there must be a consequent development, there must be one after another. And if you ingredients of that golden first principles of circumstantial evidence, we'll find a missing link. The ingredients of this golden principle says about missing link. One part it will say about the proximity of the time where the death have been caused or the events subsequent one after another. And these are the continuous things with the Moyul. Therefore, when there is no complete chain of circumstantial evidence against the accused person, they cannot be guilty of the prosecution charges. He further submitted that PW3 BN Kolita did not state that the accused came to his shop given ₹2,000 as stated PW1, as statement of PW1 is not established, being not corroborated by other PWs and prosecutions against the accused, and all the proof beyond reasonable doubt the accused entitled acquittal, Your Lordship. Now, if you go to the PW page 62, this is the cross-examination, beautifully mentioned by the trial court. Beautifully mentioned, Your Lordship. In the cross, there's a headline. If Lordship go through, it will be helpful to the further course of action. The PW1 in cross, he stated that his daughter left the house one day after the incident, telling that she is coming to the brickfield to resume her work. So this is the PW1 cross examination. Entire paragraphs are there. I just have reiterate the points which have been mentioned in the trial court, Your Lordship. Then in the page 63, he said that he in cross of the PW2, he said that he stated that accused Moinul is a mason and work in his house. He further stated he does not know who had killed the lady. Then in the mid part, in again cross of the PW3 beyond the Kolita, Your Lordship. In his cross, he stated that he knows that accused Moinul, as he was working in a village as a mason, he stated that he does not know who had killed the deceased. He stated that he had identified both the accused person when the video was played and said video was made when the accused was taken to his shop. Then, Your Lordship, PW4 Rafiqul Hussain, paragraph 12, page 64. In his cross, what he said, Your Lordship, his cross, he stated that he knows the accused person Moinul and Batsu from the time of the incident. He said that when the police took the accused person Moinul and Azizul to the place of occurrence, they were in police custody. He denied depositly that accused Moinul and Azizul confessed his presence before the police and other villagers in the field. They had killed a lady whose dead body was recovered from the place of occurrence. So Moinul, in this case, Your Lordship, Rafiqul said in the time of interrogation in the police also, he never confessed. The accused person never confessed. It is a police investigating officers mentioned in that he had confessed in the public, Your Lordship. So this is the confession of the extrajudicial statement before the police is nowhere absolutely mentioned in where it has been confessed, in which place and what time. That has not been mentioned here. Then, Your Lordship, paragraph 13, that is Tarpada Das. In his cross, he said that his dead body was not recovered in presence of the accused. In his presence, he stated that police took accused person to the place after 2 days back, where dead body of the one female person was recovered, and the day he was not present. Then, Your Lordship, PW6, in the cross, he said that he stated on the first day when female body was noticed, same police came were not present. He stated the police again visited the place of recovered dead body after 2 days back, recovered with the accused person. He further said he cannot say who has killed the lady. Then, paragraph 15, Your Lordship, page 65, in the cross, he said, he stated the accused persons are not present on the day of taking the dead body by the police. He stated that when the police took the accused person, no dead body was recovered. He stated that he doesn't know who killed the deceased. Then, Your Lordship, paragraph 66. I just going to only pinpointing the issues here. Page 66, paragraph 18, Amir Hussain, PW10. In his cause, he stated that he doesn't know why police took his signature on Exhibit 6 and he did not see any goods. PW11, paragraph 19, Jamal Ali. In his cross, he said that, Your Lordship, he stated presently, he cannot say the name of the person who had informed him about the recovery of the dead person. He stated when he went to the police station, in his presence, police recovered a statement of accused Hawk. He stated the statement of Azizul was taken by the police at the time of police station in presence of recovery of a dead body. And that time, Azizul was in police custody. He stated that he took his signature so and he had seen the money at the time of police station and taking of his signature. Lordship, page 69. I'm straightly go to the page 69 of the doctor's remark, Your Lordship. Page 69 in cross, he said that he has not specifically mentioned whether ligation mark was caused by hard substance or soft substance. That is my threshold of my argument on this part, Your Lordship. He stated that he was found strangulation mark below the neck of the deceased, but he did not mention whether strangulation mark was tough or soft. He stated constriction causes congestion of blood circulation as well as obstruction to the respiration as strangulation mark found on the neck. He stated whether congestion is venous or of cerebral anoxia is not present in his PM report. Page 16, Your Lordship. Paragraph PW 16, page 70. Most important part, Your Lordship. Her name is Zubida Khatun. She is a younger sister. Very important, Your Lordship. In cross, he stated both accused persons did not came to their house, but they made call to her sister Hasina. He stated that Moinul village Sagalsora took her sister to marry her from their house, and her sister told her that she was going to Moinul village Sagalsora to marry him. This is the part. Who is the first person? This person, Your Lordship. Moinul from Sagal Sora. She was going to Moinul of village in my marriage, and thereafter she did not return back. She stated that Moinul of village Sagal Sora took her sister Hasina to Sagal Sora. She stated she personally know that the accused Moinul Batsu committed murder of her sister after snatching of her money and ornaments. She denied the accused person did not commit murder her sister after snatching her ornaments and cash amount. Accused person not involved in the murder of this case, and I innocent. This is my point, Your Lordship. I'm totally involved. I have not been entitled on this case, Your Lordship. The seizure of the bicycles, gold ornaments, and nothing connected with this case, Your Lordship. Her old younger sister mentioned that this is the Moinul. He is the master plan of the case, Your Lordship. I'm working under one person, Your Lordship. If I have a telephonic conversation, if I left it also, the Mason, he is working under Mason for 2.5 months prior. There cannot be any person to call any stranger without having without due permission from the proprietor of the telephone mobile phone owner. I cannot call any stranger without snatching another phone. This is the case is happening here, Your Lordship. The whole entire position, whole entire case have been diverted to these two accused person, and he remains safe in his comfort zone. And he's the mastermind of this case, Your Lordship. In that case, the Hasina initially did not want to take the money from her mother because this is a hard-earned money by doing a wage labor. And that money she has been quarreling with her own mother and gold ornaments to give to this Moinul, Your Lordship. That if I give the money, then I'll be married. If I fall in love with a person, there should not be any kind of restriction in the part. It will be the part because I am not a disabled person. Yeah, I have a proposed, but it is not mentioned that you take the bank account 30 to 35,000, come with ornaments. I will give that my first wife divorce, then we will be married each other. This is the case, Your Lordship. And how the approver have been turned to a state witness when he is a prime victim of this case. And initially, the first PW1 initially treated as a name accused of this case, Your Lordship. Mere PW 164 stipend by the PW 21 along with his father and told to the court, I will be the state approver and you may be tender pardon. Now that pardon of the Chief Judicial Magistrate must be criteria from the criteria for to be a pardon. And what are the characters for to be a pardon, Your Lordship? When all the conditions will be fulfilled. Now here he make the false statement under 308, Your Lordship, he must be prosecuted. Here in all the cases, Your Lordship, it has been beautifully mentioned by the trial court, but decision come in a wrong finding. The circumstantial evidence, when it comes, Your Lordship, my humble submission before is that the call details of the investigating officer, when he has been served that you have been talked with 1:30 p.m., he has to burden of proof to be testified that I have not called for. When you go for the circumstantial evidence, Your Lordship, and assuming the investigating officer failed all the things, so then there is a part of the chemical investigation, there forensic laboratory, there is a serological test, there is a ossification test, there is a chemical test, there is a radiological test. Series of tests are there to be justified to be a certain to be a circumstantial evidence in this case. This one is failed. My learned friend already mentioned that in the initially also he has never come to the court, never come to the police, and how he is getting granting bail when he was prime accused of this case when the section 302 is concerned. So entire circumstances is the position of the case which have been led by the which have been filed by the search sheet, which no way not been fully done. Even if your Lordship go to the sketch map of that jute field, if you find there's one person, Sutupa Das, one person is there in the sketch map, Your Lordship. He has not been interrogated at that time because in that jute field, Your Lordship, there's no other person, only his jute field is there. If you go to the investigating officer of the sketch map, you will find that there's only one part. I never said that whom it comes. But the investigation part on that part is connivance with the accused, this approver, Your Lordship. In this case, Your Lordship. When the person have been murdered, then we become suspicious and we give the bail. We cannot give a bail. We maybe go to for custody. So whatever I submit, this accused person is entitled to get a benefit doubt, and he may be entitled for the accused person to be released from the jail also. That is my humble submission before this report.
Here, Lordship, I have pointed, flag marked the order when his statement was recorded under section 164. And the bail rejection order by the learned session judge, Lordship. I have flag marked, it is in the record, Lordship. Lordship, because when he appeared before the learned magistrate, there is no finding that he is a approver, he is an accused, nothing is there. That section 306 is not totally complied, Lordship. That your Lordship will find in the record, Lordship. It is there. And after rejection of the bail application by the learned session judge, a copy was sent to the IO. That observation is also there in the order, Lordship. That I have flag marked there. Lordship may peruse it. 2 flag marks are there down below. In that last record. Yes. His 164 was recorded on 22/11/2017. That order is there.
22.
11/17. And second flag mark, you'll also find that rejection order is there. It was 6/11/17, Lordship. Bail application was rejected on 6/11/2017. And that was not informed to the learned magistrate also by the IO.
Pension bond করে দেন রে, AC দিছে। AC দিছে pension bond করে দেন।
Okay.
May please, Your Lordship. Now, after seeing this order sheet, it is admitted fact that there was no pardon being tendered to Moinul under section 306. So he was not pardoned. So under 306, when someone is not pardoned, what happens to his statement? Now, before going into the evidence, before going into the merits, I would like Your Lordship to see 2 judgments. If a person is not pardoned under 306, still he can be a prosecution witness supporting the case of prosecution. Whatever statement he makes incriminating himself will not be taken into consideration. Lordship will first go to the one decision of the Honorable Supreme Court delivered in 1968 by Justice Hidayatullah. It is reported in 1968 Supreme Court 938. Of course, I have taken those printout from Manu Patra, the same judgment. It is reported in 68 Supreme Court 938, and the parties' name are Lakshmipat Choraiya versus State of Maharashtra.
Yes.
Here, what had happened, the facts are, I'll just state about the facts. Now, here, there were so many accused persons, and they were all charged under Criminal Conspiracy and Sea Customs Act. They were all found with bags of suitcases of gold transporting from here to there, and then they were charged and the trial went on. From among so many accused person, one accused person had stated in favor of the prosecution. He was not tendered pardon, but still his evidence was taken into account. Lordship will see paragraph 1 and 2 are those, 2 Lordship will see just to see the facts that I have just said, that ethyl wrong, paragraph 2, Lordship will
Yes.
see at the commencement of the trial, paragraph 2 only, ethyl wrong was examined as the first witness and ethyl wrong was one of the accused. And he gave a graphic account of the conspiracy and the parts played by the accused and her own share in the transactions. Her testimony was clearly that of an accomplice. Although she could have been prosecuted, she was not arraigned, and it is her testimony which has been the subject of a major part of the argument before us. No effort has been spared to have it excluded. In 2 appeals which we are deciding today with these appeals, the evidence of accomplices were also questioned on the same ground. For convenience of the whole question, the whole question has been considered here. Whole question means even if someone is declared an approver, even after that, what are the procedures to be followed and all. But the evidence of ethyl wrong is questioned in respect of identification of so-and-so because she was shown their photographs before her statement was taken. The use of photostat with the original is also questioned, and it is submitted that these documents should be excluded. The main argument is that ethyl wrong could not be examined as a witness because no oath could be administered to her, because under 306, no oath, even under the Oaths Act, no oath could be administered to an accused. No oath could be administered to her as she was an accused person, since under Section 5 of the Indian Oaths Act, the course is barred. And it was a duty of the prosecution and the magistrate to have tried ethyl wrong jointly with the appellants. So here she was an accused, but she was treated as an accomplice and her statement was taken and she was examined as the first witness. Now, Lordship will go to paragraph 9. Now, what happens? Whether she can be a competent witness. Because that will be relevant in our case, because Moinul, I'll rely on his judgment in order to show that he is a competent witness. And from his statement, I'll call out the circumstances. 8. Now, there can be no doubt that ethyl wrong was a competent witness. Under Section 118 of the Indian Evidence Act, all persons are competent to testify unless the court considers that they are prevented from understanding the questions put to them for reasons indicated in that section. Under Section 132, a witness shall not be excused from answering any question as to any matter relevant to the matter in issue in any criminal proceeding upon the ground that the answer to such question will incriminate or may tend directly or indirectly to expose him to a penalty or forfeiture of any kind. The safeguard of this compulsion is that no answer which the witness is compelled to give exposes him to any arrest or prosecution and can be proved against him in any criminal proceeding, except a prosecution for giving false evidence. Only for false evidence, otherwise, whatever statement he makes incriminating himself will not be taken into account. This is what the law says. In other words, custom authorities treated ethyl wrong as a witness and produced her in court. Ethyl wrong was bound to answer all questions and could not be prosecuted for her answers. Mr. Jethmalani's argument that magistrates should have promptly put her in dock because of her incriminating answers overlooks 132. In India, the privilege of refusing to answer has been removed so that temptation to tell a lie may be avoided, but it was necessary to give this protection. The protection is further fortified by Article 23 of the Constitution of India, which says that no person accused of any offense shall be compelled to be a witness against himself. This article protects. A person who voluntarily answers questions from the witness box waives the privilege which is against being compelled to be a witness against himself, because he is then not a witness against himself but against others. 132 of the Indian Evidence Act sufficiently protects him, since his testimony does not go against himself In this respect, the witness is no worse position than the accused who volunteers to give evidence on his behalf or on behalf of the co-accused. Thereto, the accused waives the privilege conferred on him by the article, since he is subjected to cross-examination and may be asked questions incriminating him. The evidence of ethyl wrong cannot therefore be ruled out as that of an incompetent witness, since ethyl wrong was a self-confessed criminal in conspiracy with others who were being tried. Her evidence was of an accomplice evidence. The word accomplice is ordinarily used in connection with the law of evidence and rarely under the substantive law of crimes. Accomplice evidence denotes evidence of a participant in crime with others. 133 of the Evidence Act make the accomplice a competent witness against the accused person. Therefore, ethyl wrong's state testimony was again that of a competent witness. It has been subjected to scrutiny and usual checks for corroboration and was therefore received with due caution. The short question remains is whether she could be administered an oath. Here also oath is administered. We have now, the Honorable Supreme Court has quoted section 5, where oath cannot be administered to an accused. Then Lordship will go to paragraph. And paragraph 10 is accused person. Lordship can skip that, Jethmalani's argument. Lordship will go to paragraph 11. There is no need to refer to the sections of the CRPC because it may safely be assumed that the word accused bears different meanings according to the context. That does not solve the problem of interpretation of same word in the court, for they have been used in one of the two senses or both. The historical reason behind the prohibition in Indian Oaths Act and 342 of the code need not be gone to any further. It is well known that formerly a person on his trial could not give evidence. At common law, then Lordship will see that how it was dealt in the common law. At common law, the parties to a civil action were not allowed to give evidence because of their personal interest, and in criminal trials, the private prosecutor could give evidence because he represents public, I think it should be public, because he represented the crown and not the accused. The common law of England was altered by statutory enactments between 1843 to 1898, and finally by the Criminal Evidence Act, 1898, the accused was allowed to give evidence. The discomfiture of the first person to give evidence on his own account while under cross-examination is also well known. He was literally carried out of his own mouth the cross-examination. Then Lordship will see 342 was quoted, and I'll just point out one particular statement, paragraph 12. Lordship will go to paragraph 12. The position that emerges is thus: no pardon could be tendered to ethyl wrong because the pertinent provisions did not apply, nor could she be prevented from making a disclosure if she was so minded. The prosecution was not bound to prosecute her if they thought that her evidence was necessary to break a smuggler's ring. Lordship need not go further. Here what I'm stating is why I'm placing this judgment is without being declared an approver, without being tendering a pardon, an accused can be a prosecution witness and he leaves the place of an accused. The second judgment, this is of course the leading judgment on that. Second judgment is more clearer. That is 2011 5 SCC 161. Now, of course, they have relied on this and they have reiterated. (2011) 5 SCC 161. Lordship has got it. Lordship will go to paragraph 42. Here the facts are, they were involved in the business of illicit liquor and adulterated liquor, and all the accused were involved, and one of them became an, his statement was taken as a prosecution witness. Lordship will go to paragraph 42.
Yes.
42 starts with, yes, the argument raised. Did your Lordship get?
42
40,
something else.
I think it's a printout from my mail or what?
The prosecution alleged.
42, my is argument raised, the prosecution alleged.
The argument raised.
Huh. The argument raised that this evidence could not be taken into consideration. And where this earlier judgment was referred. 1968 is referred. It's 42 otherwise in Manupatra. I can take out if, to save your lordship's time. It is of course down below where 68 is referred.
This SCC online.
Oh, this is SCC online. Acha, acha. The argument raised was that
Keep
this
her-
evidence.
keep her dis-
I'll find out. I'll find out in shorter time. Oh, acha, acha. This is SCC. 52. This is 78 here. Paragraph 78.
78.
Yes. Justice Kalita can also see section paragraph 78. The argument raised was that this evidence could not be taken into consideration and it would be inadmissible because this witness, though was an accomplice, he was neither granted pardon under section 306 of the CRPC, nor was he prosecuted. And the prosecution unfairly presented him as a witness for the prosecution. This was the argument. The contention is clearly incorrect in view of the decision of 1968, Lakshmipad. AI 1960. While commenting on this aspect, Hidayatullah J observed in paragraph 13 that there were a number of decisions in the high courts in which examination of one of the suspects as the witness was not held to be illegal and was not held to be legal, and accomplice evidence was received subject to safeguards as admissible evidence in the case. The court held, this is from 68, on the side of the state, many cases were cited from high courts in India in which the examination of one of the suspect as a witness was not held to be illegal, and accomplice evidence was received subject to safeguards and admissible evidence in this case. In those cases, 342 of the Code and 5 of the Indian Notes Act were considered, and the word accused, as used in those sections, was held to denote a person actually on trial before a court and not a person who could have been so tried. The witness was, of course, treated as an accomplice. The evidence of such an accomplice was received with necessary caution in those cases. These cases have all been referred, all been mentioned in so-and-so cases. Lordship can skip those. In these cases, several others cited and relied in them it has been consistently held that the evidence of an accomplice may be read, although he could have been tried jointly with the accused. In some of these cases, the evidence was received, although procedure of 337 of Criminal Procedure Code was applicable, but was not followed. It was not necessary to deal with this question any further because the consensus of opinion in India is that competency of an accomplice is not destroyed because he could have been tried jointly with the accused, but was not, and was instead made to give evidence in the case. Section 5 of the Oaths Act do not come. The court finally observed, it is not necessary to deal with this question any further because the consensus of opinion in India is that competency of an accomplice is not destroyed because he could have been tried jointly with the accused, but was not, and was instead made to give evidence in the case. The court also observes, no pardon could be tendered. This is the same paragraph. Lordship can skip that. Lordship will come to the sub-para of paragraph 78. this case would bring about the legal position that even if the prosecution did not prosecute PW 53 and used his evidence only as an accomplice, it was perfectly legal. The evidence of such witness subject to usual caution was admissible evidence. The contention of Radhakrishnan that his evidence would be inadmissible because he was not granted pardon or he was not made accused would thus be of no consequences and is rejected. In this backdrop, after considering the whole material and the findings of the jury, we have no hesitation to hold that the trial court and appellate court were right in convicting A7. So here, this is in fact, I think it is now clear, it is no res integra, that one accused, even if pardon is not granted and he was not prosecuted along with the other accused, still his evidence could be taken by the prosecution. So banking on these two judgments, I will place reliance on the Moinul here, who according to them was the main perpetrator. Now Moinul's evidence, I'll come to that when I'll come to the chain of circumstances. Now the first point that I would like to raise, now there are two set of facts, what I can see from the evidences, whether the victim went with Moinul or whether the victim went alone. Moinul was not there in the picture. This is what is little disturbing because there are few evidence where it is seen that she went with Moinul. Moinul took her. But Lordship, I'll just point out those relevant pages where this aspect is being stated by the witnesses. First, Ejahar. Ejahar, the PW1 said she went alone. Ejahar, I'll just read out, Lordship will not go into. Accordingly, my daughter left my house with an amount of so-and-so. What he said, at 3 p.m., the below mentioned accused person asked my daughter to meet him with money. That is page number 4. If your Lordship wants to go into, I'll just show.
Yes.
Ejahar, page 4, second line. At around 3 p.m. on 29/9, the below mentioned accused asked my daughter to meet him with money and ornaments with an allurement of marrying her. Over phone, not that he came and took her. It's over phone. And accordingly, my daughter left my house with an amount of 50,000 and gold ornaments. So it seems he called him over phone to meet him somewhere what is not there, meet him, and then she went. It seems she left alone. Then Lordship will go to PW1 statement, the father. Father said, he accused told her, and she said she went. Father said, Lordship will go to page 8. 5 lines from the top. Accused Moinul made phone call to my daughter Hasina. Lordship got it?
Yes.
With her promise to marry her. So he made phone call. Thereafter, one Moinul and Batshu made call. That is, Batshu is the appellant here. Made call to my daughter Hasina and told her to come with her ornaments, money, and other valuables, and they will solemnize her marriage with accused Moinul. So they call, even the appellant's name is there. Now, how he came to know, that is not discernible. But he said, Moinul and Batshu made a call and told her to come. After receiving the said phone call by my daughter left home to meet Batshu and Monirul. These are, Monirul is absconding. Batshu is before your Lordship. So my daughter left home to meet these two persons and Moinul to get married with Moinul. So according to father, these two persons had called and to marry Moinul. At that time of leaving my house, my daughter told me that she was going to Brickfield to resume her work. So she went to the Brickfield. It's not that he came and she went with him. It's not clear. Father did not say. So PW1 did not say that Moinul came and took her. Then Lordship will go to his cross-examination, page number 9. Here, of course, somebody went with her can be discernible. Now he doesn't know who was that person. Page number 9. Page number 9, the cross by defense, 5 lines from the top. Yes, 6 lines or sixth line. At the time of leaving of my daughter, I was not aware who was accompanying her. So he did not know. Perhaps someone was there, but he did not know who was that person. We cannot presume that it has to be Moinul. So he doesn't know. This is what the father said. Lordship will then go to the mother's evidence, page number 25. Page number 25. PW 14. The mother said, she asked for the jewelry and then she gave the jewelry. Accordingly, I handed over. After taking the same, my daughter told me that she was going to the brick field for her work, but I don't know where she had gone. However, I got to know that Moinul called her and Monimul and Ajizul called my daughter over mobile with her money and ornaments, and accused persons told her that they will act as guardian and would solemnize the marriage with Moinal. So even the mother said she went to the brick field for work by taking the ornaments, which she had actually deposited with her mother. So mother also said that she went normally as she goes to her work. Calling part, she again said Monimul and the appellant had called her. Lordship will just keep that one aspect in notice, that we are not against Moinul, we are only against Bachu, Ajizul. Moinul, there is no appeal, nothing is done. He is approver, he is set free. But we are concerned only with Ajizul, and we will see whatever evidence is against Ajizul. So here mother said Ajizul had called up like father. In the cross-examination, Lordship will go to the next page, page number 26. The first line, my daughter is working at Brickfield. My daughter came out of the house telling me she was going to the Brickfield for her work, and thereafter she did not return. She also did not say. It was only the sister who said. I'll come to that. So mother, father's evidence Lordship has seen. Then Lordship will go to Lordship will go to page 26. Lordship has gone to 26. Then now coming to the sister's evidence, Zobeda Khatun, who only said that she went with Moinul. So page number 29, Zobeda Khatun, she said in her examination in chief, from the bottom, Lordship will go to 1, 2, 3, 4, 5, 6, 7, 8, 9th line from the bottom.
Yes.
Now, even prior to that, Lordship can see one day, that is the day of occurrence perhaps. One day, my Moinala village called my sister over mobile phone. This is in the mid part, Lordship got it. Mobile phone, and told her that he will marry her and ask her to meet her with money and jewelry. Accused Monimul and Bachu assured and told my sister that they will perform her marriage with Moinal of village so-and-so, and they will be at her as a guardian to perform her marriage with Moinal of so-and-so. When my sister came out from house with her money and ornaments with Moinul, she says here with Moinul. With Moinul, he took her to Koraitari, and at Koraitari, Monimul and Bachu, instead of solemnizing her marriage with Moinal, snatched away her ornaments and money and killed her. Now, this is, of course, she must have presumed from the so-called confession before the police, what they have said, because otherwise she could not have this knowledge. Now, here she said that they called up and she went with Moinul. She went to this place, that place, and that finally both of them came and snatched her and did not solemnize her marriage. And next page also in her cross-examination, the Sival already pointed to me yesterday on the last occasion. Page number 30, third line from the top. Moinal of village Chagolchara took my sister to marry her from our house. My sister told me that she was going with Moinal of village Chagalkora to marry him. Thereafter, she did not return back to her house. Now, as far as sister telling that she is going to marry Moinul, that is admitted. There is no dispute to that fact. But whether at all she went with Moinul, now Lordship will go to, since 164 statement can be used as corroborating evidence, Lordship will go to page 98. What did the father say in his 161 statement or 164? Page 98. My lord, 98. My daughter Hasina Begum went to work at Brick Kiln. There she had love affairs with a boy named Moinal. They were supposed to get married to each other. One day, two persons named Batshu and Monimur of Moinur's village made a phone call to her and told her to come to Moinul's village at Koraitari with money and her ornaments. They told that they would get her married to Moinul there, but they snatched the money and ornaments and killed her. Justice Kolita has got it, yes. Then at first, Lordship will see Moinul, we will not go into. Then third paragraph, Lordship will see. Around 4:30 p.m. that day, my daughter left my house. While leaving, she told my wife, Manima Bibi, she told my wife and younger daughter Jabeda Khatun that she was going to meet Batshu and Monimur at the behest of them to marry Moinal. So she told both Javeda and PW14, the mother, that she was going to meet these two person who will get her married to Moinal. Then next paragraph, later on next day, when a dead body was found, some nearby Kolita people said they saw Manimur and Batshu carrying her daughter away on a bicycle. It was raining heavily that day. So these two persons were seen along with the deceased on that day. We will not be concerned with Manimur, but Batshu was seen taking her. What does corroboration means? Now, this statement can only be used for corroboration. Now, corroboration, I have checked the dictionary. Corroboration is what? This is collection of facts and information that backs up the prosecution story. These are collection of facts and informations that backs up, that is supporting my prosecution story. Here, they saw the father said, they made a call, asked her to meet, and finally they will get her married to Moinal. And then some other person have also seen her going on Batshu's bicycle. These statements cannot be discarded in my humble submission. So she was seen with Ajizur on the day of occurrence. And she left on 29th and her body was found on 1st. And her body was partially decomposed. So what we can deduce is she died on 29th, on 30th. She had died on that day. So on that day of occurrence, she was seen with Ajizur. This shows. Then Lordship will come to Moinal's statements in order to support the prosecution case. PW 21. Page number 39. What Moinal said is that, yes, they were having a relationship and both parents wanted them to get married. There was no issue on that part. Only what he's saying that once I was talking to the deceased, they overheard that I have told her to bring money so that my divorce can be done along with the money that his former wife was demanding. So they overheard, they took the telephone number. Now, how far it's true, we need not go into. What requires is that if he has made any false statement, he can be prosecuted. That is a different chapter. Now, from here, we will see whether some part of his statement can be relied on in order to bring home the guilt of this accused. Now, he said that they overheard, Bachu overheard, and they made a call to her. Calling part is again corroborated because father, mother had said these two persons had called. So we can to some extent believe that yes, there was a call made by Ajizur to the deceased. So what he said, Lordship will see middle part of it. I went to, after speaking to her about money and all, he went to the washroom. And then 10 lines from the bottom, Lordship will see, at that time, Bachu took Hasina's mobile number. Lordship got it. At that time, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 lines from the bottom. At that time, Bachu took Hasina's mobile. Perhaps Lordship got it. Mobile number from my mobile handset and called Hasina and asked her to bring money. After one day, her brother-in-law called me over phone that told me that Hasina is missing. And he also reminded me of the love and all. So here, they called. It corroborates the statement of mother, father that yes, they called. So Ajizur was there while making a call to the deceased. So this statement corroborates the statement of the prosecution story that Ajizur had in fact made a call to the deceased. And it could not be demolished in the cross-examination. He was cross-examined at length, and it could not be demolished. Neither it was contradicted before police. 161, of course, I have not seen. Mr. Azhar might have seen 161. 161, of course, I have not seen. Lordship will now go to the 164 statement of Moinal. Page 135. What he said before the magistrate. 135.
Yes.
Here, he says, it's a small statement only. I can just read it. I had love affairs with Hasina. I was working around Fakira Gram because they both were Masons. Fakira Gram with Moinul and Bachu. Manimul, I think it's this one. It should be Manimul. Hasina and I used to talk over phone while working. I got married earlier, but my former wife does not live with me. She told me that she would divorce me if I would pay her rupees 20,000. Whenever I talked with Hasina over phone, she used to ask me to marry her. Then I told her that if she could arrange an amount of 30,000 for me, I could give the money to my previous wife and divorce her. Later on, I came to know that Moinul and Bachu used to listen to our conversations, and they took her mobile phone number from my mobile phone when I went somewhere leaving my mobile phone behind. Later on, I came to know that Manimul and Bachu confessed that having learned that she had an amount of 30,000 with her, they called her on the pretext of getting her married to me, robbed the money and killed her. That is not relevant. Only the relevant part is that they overheard his conversations, and in fact, they took her mobile phone, a mobile number, and they called. So as far as that part is concerned, that is corroborative to all the materials that I have just placed. So the fact remains, they called, they overheard, they called. I can rely on the Moinul's evidence. They called and she went. Villagers also had seen her going with Ajizul on a bicycle. She went and she was found dead. Now, the next evidence that I would like to show is shopkeeper, because they took the money, they killed her. It was lying on the jute field. Now, the shopkeeper's evidence is, of course, a little disturbing, because the father said that shopkeeper said that two boys had come with some money and they had purchased so many things. Now, how did they get the money? They were merely Masons. Now, what? These are just circumstances that will come. It need not be proved beyond all reasonable doubt. These are chain of circumstances. So here, Lordship will go to page 8, the last few lines of this statement of PW1. page 8, a few lines from the bottom. Lordship got it? In my presence, 5-6 lines from the bottom. In my presence, shopkeeper Biren of Chakadi told police of Sapatgram police station that 2 boys came to his shop on the night of incident and purchased some goods from his shop and gave rupees 2,000 Indian currency to the shopkeeper Biren. And Biren suspected hand of those 2 boys in the murder and looting of my daughter Hasina, and police apprehended. The police, Lordship will remember, Lordship had seen, police said that on a secret source we found these 2 persons. Perhaps this can be the source, because Biren said these 2 boys had come. He might have explained to them what kind of boys, and they said it's a secret source. Of course, that should not be the statement of police. I admit it. What secret source? They should reveal it before the court. But here, PW1 said that shopkeeper said that those 2 persons comes. Now the reasonable analogy, as a prudent person, it will come that these are the person who, after taking money from the deceased, because she took around 30,000, 50,000 money. So they had purchased those goods. This can be a circumstance. Then nothing comes. Then ultimately the body was recovered. Now the body was recovered 2-3 days later. It was partially decomposed. Later accused were arrested. I will not go into their confessional statement that has no basis, no extrajudicial confession. In the presence of police, it cannot be termed as that. So I'll not take that, and neither I can take. Now the doctor's report, page number 27. What my learned friend, Mr. Dr. Gogoi said, that strangulation part. Now here, I don't know why he said that, page number 27. It is writ large in the postmortem report itself that the strangulation was not by the hands, it was by ligature, by a rope or a cloth, whatever. So in those cases, fingerprint, finger marks, nothing will be there. So here the doctor said, 1 ligature mark at the lower part of the neck below the thyroid cartilage, completely encircling. He will know, he had seen Modi's jurisprudence. And it says that when the ligature mark is down below the thyroid cartilage and it is complete, without any space, without any knot, without anything, because when person hangs himself, then the knot goes above her head and there is a space between the mark of the rope. So here it is totally complete. So it seems that person has strangulated by a ligature. It is not by hands alone. And what the doctor said, it is strangulation by a ligature. So there is no dispute with the fact that a deceased was killed by strangulating with a rope. One important aspect that I have found, Lordship will see page number 29. The next page, page number 29. This is, I don't know, this seems to be bizarre. Nothing is there apart from this statement. Here, the last lines, Lordship will see last 3 lines of page 29. I-cards of accused persons were found. Now, those were never seized also, no? Page 29. Page 29. Seizure list, subject to correction, I have not seen. What the sister says, at the place of murder of my sister Hasina, identity cards of both the accused persons were found.
No seizure list.
No seizure, no seizure. This is, I did not visit the place of recovery. I don't know from where she got I-cards of both the accused were found. This is what is really disturbing. So my humble submission would be the circumstances. I'll just call out one by one the circumstances. First, the call from Moinul, they were having a relationship, and then these 2 persons have also called from the accused person to the deceased, as stated by the mother, father, both in their statement before trial court as well as before the magistrate. Calls from the accused person, Azizul. Moinal said in his statement before trial as well as 164 that they had given a call, they overheard and given a call. Not only mother, father, but also Moinal that he had called. Then, then she left. She left to meet the accused persons, stating that those persons will get her married to Moinal. She left. Villagers saw her going on a bicycle with Azizul. This will come as a circumstance. Then she took all the money and her jewelry along with her while going. Then finally her body was found. The shopkeeper statement. Then seizure of the money. Lordship can see the seizure of the money. This is at page 111. Of course, that money, person can have more money at his house. This was seized from Marjina, the wife of Azizul, no? Azizul, paragraph, page 111. So, wife of Azizul said 502, two numbers of 500 rupee notes and 100 numbers of 100 rupee notes. And bicycle and mobile handset are not concerned with. But there was some seizure of money after the occurrence. That way, this seizure was done on 3/10/2017, immediately after the body was found. Then she died of strangulation. Thereafter, the body was partially decomposed. So she must have died on 29th or 30th. So these are the chain of circumstances that I would say which implicates Azizul. As far as the arguments of hostile witness is concerned, as Mr. Ahmed said, there's no question of hostile state. What he has placed, what I can deduce from the judgment he had placed, if a person is not declared hostile, then that statement will be applicable to the prosecution. Here, 161, I don't know what he had said, but after that, police had stated that he became a state witness and his 164 was recorded. He was not formally declared an approver, but his statement was recorded. So 161 goes out from the picture. So we are with the 164 and his statement before the trial court. And those two tallies, those two, there are no contradictions. The hostile part, not declaring him hostile, those part, in my humble submission, will not be relevant in the instant case. Then Mr. Gogoi's argument that divorce papers, Lordship has already seen her, she must have been also married earlier, and then because she was not very young, I think she was 30 years of age or what, I'll just see from the postmortem report. And then she must have married, and then it was her divorce papers with her former husband. She was 24 years of age. So it was her. So that is not relevant in the instant case. And what he said is hand marks of the fingers, that is not relevant because ligature mark doesn't call for throttling. Throttling is different and ligature mark by rope is different. So these are my humble submissions. These are the line of circumstances that I could call out in this particular case. And those two judgments I'm banking on. This is my humble submission.
Just here in this case, what my learned friend has said, Lordship, just with great respect, Lordship, to her submission. If your Lordship accept her submission, it will give a wide, ample power to the investigating agencies to diverse a investigation in any direction they want, Lordship. Because admittedly, PW21 is the FIR name accused. PW16 clearly says that he took the victim with him. There are materials on record. Learned Sessions has rejected their prayer. There is specific section in the CRPC that if an accused, they want to adduce the evidence of accused, then how procedure has to be followed. Section 306 is there. Therefore, that has to be followed. Otherwise, they can arrest any person in collaboration with the accused and produce before the court and adduce his evidence of the accused person that these are the persons here that killed the other person. I have seen this. Will the court go by that evidence, Lordship? Certainly not, because Lordship, the prosecution have to follow the procedures established, procedures in the CRPC, Lordship. They have to follow it. And the first submission, Lordship, what my learned friend has said that regarding the evidence of PW 21, she submitted two judgments of this, two judgments of Honorable Apex Court. What I have found to subject to correction, Lordship, in those cases, the persons implicated themselves as well as the other accused persons. They were the accomplice. Here, my submission is not that. My submission is that the investigation was diverted from one angle to another angle. And this appellant has been convicted by screening the main accused. My case is different, Lordship. That facts of those two cases are not applicable in my case. Admit in that cases, Lordship, but I have in short time I have perused, Lordship. It shows that they were accomplices. They stated before the court in similar manner. But in my case, what PW 21 is saying, that I am innocent. That is what I can understand, Lordship. He is simply denying that I have not called, I have not met her. He is simply denying everything. He is not an accomplice here. So those two judgments will not be applicable in my case, Lordship. And second thing, Lordship, what my learned friend is relying on the circumstances that this present appellant along with another accused called the deceased. This is not an established fact because the circumstance, this case is based on circumstantial evidence. The circumstances which is relied on by the prosecution, that has to be established fact, Lordship. I have already placed the judgment that Sharad Bidichan judgment is relied on. That says established fact. Here why I am saying, Lordship, the affair was lodged on 2. The present appellant along with another was arrested on 3rd. And the conversation between deceased and the appellant along with the co-accused were only known to the deceased and the appellant and the co-accused. None other knows about it. Even PW 21 is saying, I heard. He suspects. Those things are there. Even he is not sure. He says, I cannot say exactly when my phone number, they have taken the phone number or talk. Is it an established fact? In my humble submission, no, Lordship. And second thing, which I have already pointed out, FIR was on 2nd, they were arrested on 3rd. Neither the PW 21 came forward, nor the other any person came forward. How these two persons were arrested on what basis? He says secret information. Is it enough for the court? I will submit no. Because he has to disclose what is his source. Was his secret source the PW 21? The question arises, Lordship. Prosecution has to answer it. Because this case is based on circumstantial evidence. They cannot throw away one view and take one view to convict the accused. Because in circumstantial evidence, if two views are possible, which is favorable to the accused, that has to be accepted. So one view I have pointed out before your Lordship, that Moinil may be involved. I'm not saying he is involved. May be involved. What appears from the prosecution witnesses, Lordship. That PW 16, sister of the deceased. My learned friend says that it is not relevant. But what the Honorable Apex Court said, that prosecution is bound by his evidence. We cannot say sideline the evidence of PW 16 as held by the Honorable Apex Court. If that view remains, that admittedly there is two views. One view that Monol took her to his village. That your Lordship, just again I am taking page 29. Even she categorically said the place, name of the place, page 29. Ninth line from bottom, page 29, Lordship. When my sister came out from her house with her money and ornaments with Moinal of village Sagolsora, he took her to Koraitari and at Koraitari accused Moinul but also other camps subsequently. So it is a specific case of the PW 16 that the deceased came along with Moinal. And subsequently in cross also she affirmed that part. So her evidence cannot be brushed aside. And if it cannot be brushed aside, her evidence gives a two view, the another view, Lordship, that goes in favor of the accused. And second, Lordship, the circumstance which my learned friend again said that the appellant along with co-accused called the deceased. Again, I'm placing before the Lordship that when this fact came to knowledge of the IO, only when the PW21 came forward. Prior to that, PW1 nowhere said, his statement was recorded 4 times. Prior to coming forward of PW21, there was nothing on record. Even in this aspect, Lordship will find, because call was made from the phone of PW21, not from the phone of accused persons, Lordship. And therefore, Lordship may kindly turn to page 36, evidence cross-examination of the IO. Defense had therefore categorically cross-examined the IO regarding call details report of the deceased. 7th line of cross, Lordship will find, I did not collect the call detail of deceased Hasina. Why not? Because there are cases that we have called, from whose phone it was call was made. They have to prove it. Because circumstances has to be established circumstance. That is why I am stressing, Lordship. Their allegation is that we have called. From whose mobile phone we have called?
Basically, that's all.
Basically, that is the thing. Because Lordship will find that from the evidence page 34 also, he says he arrested the person only on the basis of secret source. What was the secret source? Nothing is there. And the other fact which my learned friend has said, that PW1 says that initially Biren Lordship suspected that this person has used 2,000 rupees. So therefore police might have arrested that person on that basis. I accept that PW1 admitted stated in deposition. That is not there in 161. Apart from that, that Biren is examined as PW3. Lordship have already seen in the other day that he has stated nothing about his suspicion. That secret source is remain all secretly, Lordship. Okay. That is my submission.
I beg to just point out the learned defense. If I have been treated as an approver, is there any mention in his examination that these 2 accused persons are being held for the commission of an offense? Is there any whisper of any statement stated as a state witness, Your Lordship? He mentioned in his statement in PW21. Only one part, Your Lordship. If you go to the page 40 of the last part of the cross-examination, it is another fact that I am the accused of this case and falsely implicate accused Batsu and Moinul deposed falsely before the court to save my skin. It is another fact that I made statement before the police as told by the police. It is another fact that accused Batsu and Moinul are innocent. So, assuming if I treated as a state witness or there is no any whisper of a single word against the accused person, other persons. I leave alone all the materials and facts. I just want to point out one point.
Okay.
That's the point.
But Mr. You want HRA's name or what? Mr. HRA Chowdhury, Learned Senior Counsel, assisted by Mr. A. Ahmed, Learned Counsel to the appellant. Also heard B.N. Gogoi, Learned Security, as well as M.S. Jahan, and hearing concluded, just please.
Obliged.
Item 3,
3, which baby was there, father? Here, a 7-year-old child was raped and murdered in a very pathetic condition.
POCSO,
It's a case of
Maybe the
eyewitness, Lordship.
are you ready to do with the LCR?
I have gone through in the code itself, I've gone through the records. The lordship takes up and ready to do, but I don't know whether he'll finish it by 1 o'clock.
May be possible also. There are 8 PWs, that 2. I will go through the PW the depositions, and thereafter, Lordship, there is no 164 statement.
There is,
There is no,
I've gone through the records.
but 164 has not been exhibited.
Rahul Bormont, PW3, it's in the LCR, I don't know.
It's not exhibited, not exhibited. Not exhibited, Lordship.
No 164 statement.
No
I have
164
found it in,
statement.
this
not
one,
exhibited.
LCR.
And Lordship, there is, I have gone through the entire Lordship facts, Lordship, the place of occurrence is doubtful in this case. And presence of the eyewitnesses are also doubtful. There are 3 eyewitnesses, Lordship. So they have contradicted each other from what I have gathered, Lordship. So it will not take that much of time, Lordship.
You can continue. If you want to continue with the paper book, then we can give you a date.
A short date be given, raised to be directed to provide me a copy of the paper book. Lordship, and go through it.
Let her get.
And 164 statement, I have checked that,
Because here she's saying there's a 164 statement.
but
You
it's
are saying there's
might
no
not have been exhibited. I have not gone to the
164
paper
has
book.
not been exhibited.
So that has not been exhibited.
So that has no relevance, Lordship. It has not been exhibited.
Then I'll give you a short date.
Yes,
Hurt Mr.
And Hassan, Lordship.
N. Hassan, then it can be distributed. What they have done. Registry is directed to furnish a copy of the paper book to MSB Buyan, Learned Additional PP. And list the matter after,
after a week,
after 2 weeks,
After 2 weeks, after a week,
after a week, your lordship.
after 1 week.
oblige.
8,
I'm sorry, your lordship, his matter, there is no 164. And the later one, it has, I'm sorry, in submitting, I mixed up. 8 also same lordship, no paper book has been provided. I have gone through the records. Councils are not here. Ornang Shudar, he was there, my God. He said he'll do. Here are also 8 witnesses. There is a child witness,
This
Yes.
was a POCSO.
yes, a husband killed his wife.
None, amicus curiae is absent. Registry is directed to furnish a copy of the paper book
Right.
to MSB Buyan, Learned Additional PP Assam. And list the matter after 2 weeks,
In the next week,
1 week.